Hi folks, and welcome back to Contract Law. This is video 2 in the video series on the V3, Duress, Undue Influence and Unconscionable Conduct. And in the first video we had a quick overview, particularly in relation to the common themes within the V3 and the ways that you can tell them apart. So now we need to delve into each of these vitiating factors in a little bit more detail. So we'll start with duress in this video. Now, as we said before, there are 3 different types of duress: duress of person, duress of goods, and duress of money, that is economic duress. You need to show that the threat you're complaining about constituted illegitimate pressure. That test was introduced by Justice McHugh in the Crescendo Management case, High Court case in 1988. Subsequently, there was a bit of talk about, what exactly is illegitimate pressure. Bit of a vague term, really. What does it mean? Does it mean something that's actually unlawful, or is it something a bit less than that? Where are the boundaries? Are there any boundaries? We kind of really need boundaries in a vitiating factor like this. So consequently, Justice Kirby, when he was on the New South Wales Court of Appeal in the subsequent 1993 Equity Court case, doubted this phrase illegitimate pressure and said really what you need to find is some kind of unlawful conduct. Things like threatening to break an already existing contract in order to extort some further monies out of the person, that kind of thing. Much clearer to draw the line there. So you do need to have basically unlawful conduct. I quite like the way that the Wilmot text actually expresses it. It says, duress may now be taken as meaning actual or threatened unlawful conduct that's directed at the personal property of the victim or the legitimate commercial and financial interests of that party. So you're looking for some kind of naughty conduct, unlawful conduct. It has to be irresistible pressure. So here, as I said, with common law, the requirements are quite strict, and if the threat is something quite trifling that wouldn't bother the average Joe, then it's not going to be the kind of threat that's going to qualify in terms of duress. So it has to be irresistible pressure, something a reasonable person could not be expected to withstand.
I'm going to make him an offer he can't refuse.
If you can hop over those things, you might find that the threat is against not one of the parties to the contract, but one of their close associates, a third party, but someone close to one of the contracting parties. If that's the case, certainly duress may well still apply. However, if the person applying the duress, the threat, is not one of the parties to the contract, but a third party, then you're probably going to have difficulties, aren't you? Because if you're trying to get out of a contract, and that's normally what you're trying to do with an action in duress, then you've got to sheet home that naughty behaviour to the other party to the contract in order to get out of the contract. So that is just like a bit of foundational work in terms of duress. I want to run through 3 cases that establish the 3 different kinds of duress. Contract law, certainly, as I've said many times, contract law throws up the best case law probably that you'll encounter in your law degree, and this video series will have quite a number of, I guess, my favourite cases in the entirety of contract law. And the first one is Barton and Armstrong. This particular case reminds me of the 1983 movie Getting Square. If you haven't seen it, you absolutely must. Fabulous movie set on the Gold Coast about the typical white shoe brigade.
I'm square these days. Ask anyone you like. They can't deny.
It all surrounded the development of what is now a suburb of the Gold Coast, just a stone's throw from myself, called Paradise Waters. Now, while Paradise Waters was being developed, the development company hit a few snags, as is not uncommon, and there was various tensions amongst the directors in the main company that was conducting the development. There emerged some factions amongst the directors, and what effectively happened was one of the directors was kind of pushed out into the cold, if you will. Leave me out here in the cold. He was voted out of all of his management positions and so on, effectively denuded in terms of power in the company. And the plaintiff and the defendant agreed to a deed whereby the plaintiff was going to buy this defendant out from the company altogether. They just wanted to get rid of him. And at this point, you're probably thinking, what happened to this poor little man? This is Duress person, so it must have been fairly ugly. Actually, it was the person that was muscled out that ended up making the death threats, not just once, but quite a number of times in quite a number of ways. Started off with some phone calls and heavy breathing, saying that, sometimes saying, "I'll kill you," to shouting across the table at board meetings, "I'll fix you." So much so that the other director ended up getting a bodyguard, and at a subsequent board meeting, Armstrong actually shouted across the table, "Doesn't matter how many bodyguards you get, I'll still fix you." This was some fairly outrageous behaviour. At one point, the plaintiff even moved houses, got out of his house because he was worried about the person that Armstrong had actually contracted to kill him, shadowing him around and watching all of his movements.
I'm going to make him an offer he can't refuse.
So you guessed it, the other director signed the buyout deed. This made Armstrong enormously happy because he was paid so much money under this buyout deed that he effectively made the company go broke. So he thought he walked away very nicely as the victor in the tense relationship there, and also basically sending the company broke. However, Armstrong's world started to unravel when the hitman that he had contracted approached Barton and said that he'd really rather not conduct the hit after all if Barton would just pay him the $2,000, rather cheap. And Barton convinced the hitman to go to the police with him in order to have the middleman and Armstrong apprehended and brought to justice. The case went through the New South Wales Court of Appeal and then up to the Privy Council when that avenue of appeal was still available. And it set out the elements of duress very nicely and clearly for us. As you can see over on the right there in the yellow, you must have a threat of death, bodily harm or imprisonment. Well, we certainly had threats of death here several times. Calculated to cause fear. Well, yes, it did. It certainly did cause that fear. I mean, the poor man moved his house. There was a lot of discussion about whether or not it had to be the reason for entering the contract. That is, would it have to be the case that you wouldn't have entered into the contract but for that threat? And the court said no, where you've got threats, extreme threats to your person being made like this in this kind of duress scenario, they only need to be a reason for entering the contract, not the sole reason for entering the contract. Conduct like that is just reprehensible, and yeah, it's calculated to cause fear. If it does, well, as long as it's a reason, you can get out of the contract. It's for the defendant then to try and prove that the threats played no part whatsoever in the decision to contract. Very high hurdle to get over. You will note that even though this is a common law action, the result of a successful argument of duress is that the contract is voidable only. Voidable, not void. So there was a bit of unclarity about that for some time, but the consensus now seems to be that the contract will be voidable. So that's duress of the person. Now let's have a look at duress of goods. Here we have the case of Hawker Pacific and Helicopter Charter. And the defendant in this case was in the business of repairing helicopters. He did a paint job on a helicopter. Unfortunately, their work was less than excellent quality, and the plaintiff decided to send the helicopter back for the defendant to redo the paint job rather inconveniently for the defendant. The plaintiff then tried to collect the helicopter after the paint work was corrected. They needed it for an urgent charter the next day. Unfortunately, when they arrived to collect the helicopter, they made the mistake of mentioning the fact that they needed it for the urgent charter the next day, at which the defendant had an aha moment.
Oh, come on!
Light bulb.
And spied their opportunity. Wonderful little vignette of human behaviour here. So they decided that before they would release this helicopter, they would require the plaintiff to enter into an agreement. Now, the agreement had two salient terms for our purposes. Firstly, an acknowledgement of the amount that was due for the paint job. Well, that's fine, no real problems there. Secondly, releasing the defendant for any defective work. So if they did a poor job this time, they certainly didn't want to have to repeat the effort and redo the job again. They just wanted to, they wanted their money, and they wanted to see the back of these people.
Go away!
So they decided to present the contract, and you guessed it, the plaintiff signed because they had this urgent charter, and then they objected to the contract as being conducted under the cloud of duress. The court discusses here the old cases on extorting goods and withholding goods in order to get a payment. And they said, well, you know, if you're going to allow that kind of thing, relief in those circumstances, it's no real stretch to analogize from that to saying, well, you should give relief to the circumstance where someone's withholding goods not to get money, but to get a contract signed. And so you guessed it, duress of goods was successful in that scenario, and the contract was voidable. So that's Hawker Pacific and helicopter charter, and that's duress of goods. The final case that we need to look at is a case of economic duress. Now, this form of duress is the new kid on the block so far as this particular vitiating factor is concerned. Obviously, duress started out with duress of person, expanded to duress of goods, but for a long time there was resistance to the notion that you should be getting relief for threats to your economic well-being. It was thought that a person of reasonable firmness should be able to resist threats where all that was threatened was perhaps your money. Nevertheless, once the expansion of this doctrine had started, it was kind of more and more difficult to constrain it. There's no real reason to deny relief just because the nature of the threat impacts upon your economic well-being rather than, you know, your personal, your goods, particularly your goods. And the case that everyone cites here is the North Ocean Shipping and Hyundai case. And what we had here was North Ocean contracting with Hyundai. Hyundai was going to build this very large tanker called the Atlantic Baron, worth many millions of dollars, as you can imagine. Under this agreement, Hyundai provided a reverse letter of credit. And what is that exactly, you're asking? It's essentially a form of security, and Hyundai gave it to North Ocean as comfort that if Hyundai happened to default in the terms of the agreement, that North Ocean could take this reverse letter of credit to their bank, and they could say, please pay us back all of the payments that we've made under this contract. So it was basically like a refund letter, I guess you'd call it. It gave the parties comfort that, the right thing would be done. Payments were to be made in 5 equal instalments. And unfortunately, after the first instalment, the US dollar devalued by around 10%. Now, this was rather disastrous for Hyundai. It meant that it would have lost around $3 million on the deal. Hyundai weren't going to take that line down at all. And so they turned around and said to North Ocean, okay, you've paid us the first instalment, thanks very much, but from now on, all of the rest of the instalments are going to be increased by 10%. So they were effectively passing on the impact of the devaluation of the US dollar. North Ocean were in a bit of a pickle at this point because not only was this a very expensive deal for them, but they really needed to ensure that the contract was performed on time because they had a rather large deal with Shell that kind of hung on them getting this new Atlantic Baron into the water in time. You didn't have that extra layer of pressure that you had in the Hawker Pacific case, the helicopter case, because North Ocean didn't actually tell Hyundai that it had this large deal in the wings. But nevertheless, that was one of the factors that was kind of pushing them towards signing on the dotted line when Hyundai said that they wanted the extra payment. What they ended up doing is they said that they would agree to firstly maintain an amicable relationship with Hyundai, and secondly, very importantly, they said that they would agree without prejudice to their rights. Now, that is a key legal phrase that I'm sure you'll use many times in the course of your career. Essentially, it signals that your client is going to do something, but they reserve their right to complain about it later, okay? So that's the basis on which the extra monies were paid over in the instalments. In return, this was quite important, in return, when North Ocean said that they would make the increased amount of the instalments, Hyundai said that they would increase their reverse letter of credit so that if Hyundai did default, then the higher amount of instalments would have been refunded back to North Ocean. There was a lot of discussion around what the effect of all of this was, the agreement to pay extra money, and in return, the increase to the reverse letter of credit. And as you can see, it's a promise being exchanged for consideration. And the court said there was this threat and then there was this contract to vary the original contract that had the lower instalment amount. So was that contract affected by the vitiating factor of economic duress? Yes, indeed, folks, it was economic duress that affected the contract to vary the terms. There certainly was no legal justification for Hyundai demanding the extra 10% increase to the originally stipulated amount of the instalments. Both parties here knew that Hyundai was firm. There was no way they were going to accept less than full agreement to passing on this 10% loss that they would have otherwise made. However, and this is yet again one of those cases that highlight the very unfortunate nature for some of the consequence of a contract being held voidable and not void. The fact is that if a contract is rendered voidable only, then you must act on your rights very quickly, otherwise there is a danger of acquiescing conduct being construed as affirmation of the deal. And here it was held that North Ocean were freed from their situation of duress. They had another tanker that they were also having made by Hyundai called the Atlantic Baroness. That was playing on their minds, but the court held that that didn't actually keep them under a situation of duress at that point. Once they'd paid over their last payment, they were pretty much freed from the situation of duress. However, there was a couple of unfortunate things. As I said, they delayed from November 1974 until July 1975 before they spoke up. And also, the last payment that was made was done without making any protest. So, unfortunately for North Ocean, even though they had a good cause of action, they lost it. It slipped out of their hands, and that delay really did cost them very, very dearly. So that is the case of North Ocean Shipping and Hyundai, and that's economic duress. What we really need to speak about now is the issue of remedies, and the Hyundai case leads us very nicely into the remedies that are available. Obviously, rescission is the big one because the contract is voidable, so you've got to put your hand up and say, I rescind. You can ask for restitution of your money, so to get your money back or your property back. There has to be substantial restitutio available there. There is still some lack of clarity on whether or not you can get damages. If you can get damages, they will be available in the tort of intimidation. Obviously, you're not going to get contractual damages because you're not suing on the contract for a breach of the terms, are you? You're suing for something else, a vitiating factor that's gone on. You should also note that the Australian Consumer Law in section 50 sub 1 deals with a new statute, well, when I say new, since the Trade Practices Act was enacted, which then morphed into the Australian Consumer Law. We now have the statutory prohibition on harassment and coercion. And you can see there, I've just lifted that out of the legislation. A person must not use physical force or undue harassment or coercion in connection with supply of goods, payment for goods or services, sale and purchase of land, or payment for an interest in land, very squarely targeted at consumers there. I'll leave you to read it on further in the text regarding that one. What it does do, the key thing to remember is that if you can sue on the ACL, then of course you're going to be suing on all of the different remedies that are available in the ACL, including those nice ancillary orders that allow the court to tailor the remedy pretty much to your needs. So these are the kinds of remedies that are available under the ACL, as we've seen in a previous video series. So that is the issue of remedies, and that is the vitiating factor of duress. And we'll leave it there for this video, and I'll see you all in video number 3 for undue influence. Bye for now, guys.